Human rights are in the news again as some of our favourite right-wing demagogues are pushing to leave the European Convention on Human Rights. Rishi Sunak said controlling our borders is more important than being a member of a foreign court. That's because he fears the plan to divert asylum seekers to Rwanda won't pass muster under human rights laws, which require that people not be sent somewhere where they face a real risk of inhuman or degrading treatment. I used to be a human rights barrister and I studied law in the UK and the US, so I know a thing or two about this subject, and I want to talk about why we should care about human rights in the UK and why we should resist the trap of vilifying the European Court of Human Rights as some kind of foreign usurper. The way this stuff is talked about is insulting to our intelligence, and so I want to correct that. Equally, it's also very easy to become quite right-on and sanctimonious about this stuff and act like it's some kind of immutable truth. I used to be like that, but I'm going to try my best not to do that here. So what are human rights? In a legal sense, they are certain basic rights and freedoms that a government must respect and protect for individuals under its power. Those include the right to life, the right not to be tortured or enslaved, the right to liberty, the right to a fair trial, the right to privacy, freedom of expression, freedom of religion, freedom of assembly and association, including being part of a trade union, and freedom from discrimination. And the rights have effect by being enforceable in court. If you believe the government has violated your rights, you can sue them. And if a court agrees, it can grant a remedy, like release this person, compensate this person for beating them up, apologize and acknowledge a wrongdoing and clear this person's name. They can even sometimes void a law that falls foul of a higher law of human rights. Where do human rights come from? If we trace the history of human rights in the West, one of the earliest mentions of them is, of course, Magna Carta from 1215. These were barons imposing limits on the king. Then, about 400 or 500 years later, you have the Enlightenment, where this idea arises that humans, or at least some of them, have certain rights simply by virtue of being human. That idea goes back to Greek and Roman philosophy and is expanded by Christian philosophers with the idea of natural law, that humans have inherent worth because they have the power to reason and know right from wrong. Elsewhere in the world, you can find these ideas in history too. For instance, India's Buddhist king Ashoka, not Asoka, published edicts on pillars in 262 BCE that set out freedom of religion and the right of condemned prisoners to make an appeal. But the modern trend of what ultimately became today's idea of human rights began with the Enlightenment. The revolution in England inspired John Locke, who wrote about social contract theory and in turn inspired American settlers to revolt against the British king. But if humans suddenly have all these rights just because they're human, what do you do about slaves and natives? Move the goalposts and define them as less than human. I'm not even joking. Slaves were still defined as property, and natives were defined as barbaric savages with children's minds, and that justified conquering and dispossessing them. So the lesson is that human rights are always a political claim. They are always the product of revolutions and responses to injustice. A global history of bloodshed, terror, and despotism has informed a growing consensus that there are certain things human beings should be guaranteed. That really came to a head in World War II, where the most despicable things were done to people. The dehumanization and genocide of an entire race that almost resulted in their total elimination. The Allied powers said never again, and with their newfangled United Nations, they put forward a Universal Declaration of Human Rights, later turning this into legally binding treaties, the two covenants, and regions have their own ones, the Inter-American, the African Charter, and the European Convention. But that wasn't the end. World War II was followed by the Cold War, in which atrocities were committed by dictatorships in Latin America and the Middle East, and they were put into power by CIA coups against democratically elected socialist governments, and equally campaigns of terror by communist regimes. The promise had been made, but the world still had to live up to it. And it might never, because rules are always going to be broken. The question is whether we will allow a bunch of vandals to make us think that the rules are the problem. In 1948, Winston Churchill pushed for a European Charter of Human Rights, and so one was drafted, led by a British Lord Chancellor and former Nuremberg prosecutor, and this was adopted in 1951. Until then, Britain never really had a proper Bill of Rights in the way that other countries do, probably because our revolutions were always partial. We had some laws that set out rights that you'd expect to see in a Bill of Rights, and case law that essentially protected similar rights. But this wasn't the best setup for a modern democracy. So the European Convention system set out these rights for people in all the countries that signed up to it, which was most countries, and allowed them to take their country to court for violating it. What court? The European Court of Human Rights in Strasbourg. Now, this is not the EU. Not the EU. It's the Council of Europe, not the EU. Wait, why should a foreign court get to judge us? I mean, admittedly, it's a foreign court that has a British judge and a judge for every member country, but still, why? Well, firstly, because our own courts couldn't hear these cases. They had no power to apply human rights laws and scrutinise government acts or UK laws. They could only do this very tortured legal logic where they say, is what the government's done here so unreasonable that no reasonable person could do it? Secondly, look, we've always been a bit complacent as a nation. We like to hold ourselves out as this shining paragon of democracy and integrity, but we're no more immune to corruption than anyone else, and we can easily sleepwalk into autocracy. We're all human, and the same lust for power occurs everywhere, so why not learn from each other's experience? If you want to see what I mean, look at MARPA versus the UK. Our highest court, the House of Lords at the time, didn't think a police database retaining the DNA of all people who were arrested but never charged even affected the right to privacy, so the government didn't even need to have a reason to justify holding on to it indefinitely. The ECHR found this pretty naive. I mean, part of the UK's argument was actually, we don't think the police are going to do anything bad with this, and it would be rude to presume that, when they should have been thinking, hey, you need to have a really good reason for holding on to this stuff. Next case. The post office used to have the power to tap people's phones, and it could do this if it had a warrant from the Home Secretary. But the Home Secretary's power to issue these warrants of surveillance was not set out in any law. And the UK court said, well, there isn't any law that says it can't, so it's fine. And the European court said, are you crazy? A minister of the government should not be able to authorise surveillance without an explicit legal power allowing them to. Now, otherwise there's no right to privacy. It's a whole mentality thing. If sovereignty is with the king, then it's they can do whatever they want unless there's a specific limit on them. If sovereignty is with the people, then the government can only do the things that we have expressly granted them the power to do. So in the 90s, there was this realization that the UK is constantly getting fined by the European Court. Why don't we just let our own courts hear these cases? And so the Human Rights Act was passed. And the Human Rights Act has been used to protect, for instance, the rights of protesters, as in the Laporte case, where the police sent buses of protesters back down south of London based on the vague perception that maybe they'd be disorderly, and the House of Lords said no, you can only interfere with their protest and freedom of speech rights if you really perceive imminent illegality. It's protected journalists like Sally Murrah, who the police obtained a warrant to listen to her phone calls from a judge, but they left out the fact that she was a journalist. And at her trial, it was ruled that they'd violated her freedom of expression, and they couldn't use that tap to prosecute her for receiving information from a whistleblower in the police. It's protected kids. The case of Williamson, where the Supreme Court decided that parents' freedom of religion does not outweigh the government's right to ban corporal punishment in schools. The families of the football fans who died at Hillsborough were able to use the Human Rights Act to force an inquest that ultimately found that the fans had died due to negligence and it wasn't their fault. And also, a couple pushing 90 used their right to family life to stop a local authority from separating them and sending them into different care homes. Okay, so what's the criticism? Well, the government, not just this one, often casts this as a battle between stopping the boats, stopping criminals, stopping terrorists, and obeying the dictates of this activist foreign court. And they say that if we didn't have to follow this activist foreign court, we could do what we need to do. Is that true? Well, there have been several cases where the European Court, or even our own judges for that matter, have held that, for example, the government can't deport terror suspects to countries where they'd face a risk of torture, or they can't detain them indefinitely, or they can't use evidence of their trial that's been obtained by torture. One case that comes to mind is Abu Qatada. Remember, though, that if we only apply legal rights to people we like, it's a bit of a slippery slope. There were also ping-pong matches between the UK and Strasbourg court about whether you could convict somebody purely based on hearsay evidence, and the European court eventually relented. There was hue and cry about prisoners being able to vote. Now, I just point out that the government has criminalised lots of forms of protest, so in theory it could jail a bunch of protesters, and then that way critics of the government can't vote. Judges have held that you can't deport a foreign criminal because of their family life rights in the UK, including that they have a cat here. That was a lie, you know. Alright, I agree that Article 8, the right to private and family life, is quite vague and it lends itself to judicial activism. But it's also worth pointing out that the government wins most of the time. Also, remember that the mere fact that a government can't do what it wants doesn't mean the system is wrong. Otherwise, we would live in a dictatorship. Let's follow the logic here for a second. Let's say the UK leaves the ECHR. I don't think it would tear up the Human Rights Act completely. I think it would replace it with something like Dominic Raab's Bill of Rights. The UK courts would still be able to apply these rights to government actions and UK laws, albeit with some constraints that could be problematic. Here's my fear about this in our system. The UK Parliament is sovereign. As we know, a party doesn't have to get a majority of people's votes to get a big majority in the House of Commons. Power is immensely distorted, and they can then pass laws that effectively amount to fiat, like the Rwanda bill that forces courts to decide that Rwanda is a safe country in spite of all the evidence, and forces them to disapply the Human Rights Act. It's legalized lawlessness. And it's not even tyranny of the majority, it's tyranny of the inflated party. I mean, just look at what they've done to protest. Laws passed in the last 2 years have allowed the police to ban protests because they're too noisy, or because they're more than a minor disruption, or to arrest people based on the possibility that they're carrying something that might be useful for a sort of vaguely defined unlawful protest. And you can't really rely on goodwill or common sense in how these are interpreted and applied, because just look at the coronation, where the head of Republic was arrested by the police for carrying luggage tags, and the police, later on said, okay, we made a mistake. But critics of the monarchy were shoved in a van for hours. It's not a great look. Powers will be misused. That's why you draft them narrowly. The ECHR isn't perfect. There's definitely overreach. I mean, I don't think the court should really be ruling about climate change, but we should be very careful to tear up something so fundamental. We should be secure enough in our ways not to feel that the peer review of other countries is a threat. If these are truly human rights, then surely the shared experience of humanity should guide their operation. People fought and died for these things. Don't let a bunch of lightweight chancers tell you they know better.